A message from our sponsor. Need a current or retrospective SMSF property valuation? Whether it's for annual financial statements, pension commencement or related party transactions, SMSF Property Valuations offers fast, reliable and audit-ready reports across Australia. As an accountant or SMSF trustee, do you need a valuation that satisfies ATO rules, includes documented methodology and ticks all audit boxes? SMSF Property Valuations delivers an easy online ordering process to finish the job quickly. Hello everybody and welcome to another episode of the Cross Country Super Podcast. And as usual, I'm joined by Jemma Sanderson all the way from Perth. Hi Jemma, how are you going?
I am good, Darin. How are you?
Yeah, I'm not too bad actually, coming off a bit of a busy stretch, but that's okay. That's what we love doing. Now, today we're going to delve into a little bit of estate planning uh, issues, practices, I suppose. And in particular, we're going to talk about binding death benefit nominations because while on the surface they might appear to be a fairly simple concept and construct, but there are so many intricacies that people need to take into account to make sure that the nomination and what the wishes of the person who is associated with that nomination uh, uh, make sure the wishes are actually carried out. Because I don't think there's anything worse than, oh, I thought my death benefit, not that the person would know because they're dead,
They're dead.
but but
Oh,
the
sorry, I
fighting
shouldn't laugh.
parties, the fighting parties subsequent would be feeling trauma that the dead person's wishes aren't being respected because there's some sort of challenge or some sort of technical difficulty. So yeah, we're going to cover some of that off, and no
Yep.
doubt there's certainly some really great court cases that have established some sort of precedent as to what you should and shouldn't do or where you might get caught out. But I'm sure, Gemma, you've probably got some war stories to tell us about as
Oh
well
my goodness.
in
Yeah,
in this
absolutely.
regard, and we all love a good war story. But
Yes, we do.
why don't we start by just going through, what a binding death benefit nomination does, and how important it is in the world of estate planning, and the usefulness, because obviously you've got that delineation between what happens with your super benefits and your will, and that's obviously sometimes a little bit convoluted. So why don't we start there?
Let's start there. So, I guess the thing with this is, like you were saying, there's all these little nuances, and it might seem like it's just a simple little, oh, it's just a document that someone signed that says these benefits are to go here. But that's kind of the tip of the iceberg. And if you don't have all that iceberg underneath proper, then the tip just, spins around. I don't know, that's a really bad analogy. So, that one little hole in the Death Star, you get that one
Yes,
little thing. Got my
yes.
Star Wars reference in there. All
Yeah,
right.
very
So,
good.
so the binding death benefit nomination, particularly in an SMSF context, is really, really important because in the absence of having a written instruction that might be binding on the trustee, then depending on the deed, but by and large, the decision about where those death benefits are paid then rests with the trustee of the fund. And so then that's a whole other succession sort of consideration on who is the remaining trustee. So I'm talking perhaps in a husband and wife or couples sort of scenario, but with blended families, you might want the assets to go to the first children, but the surviving spouse is the remainder trustee, and they might exercise that discretion in their favour. And then all of a sudden, you're just opening yourselves up to some legal dispute action. And that just costs a lot of money. The lawyers are the big winners there. So apologies to the lawyers listening in. Probably like, Jemma, be quiet. But yeah, it takes a long time. So you mentioned that some cases, a lot of these cases, there's been between the person's death and it all being dealt with through the courts, it can be like 4 years. So that's a long time for beneficiaries to be sitting there in limbo, or even potentially not able to meet expenses and things like that because their super fund is wrapped up in some legal action. And the other thing is, a lot of people have the misconception, and you mentioned, oh, that's not where I wanted my super to go when I died, but you're already dead, so you wouldn't know that that's what's happened. But we
Yeah.
often will sit with people and say, okay, Darin, this is how your estate is mapped out with your current documents, and your super is actually in the control of your oldest child, who you put into the fund, who's got a $5 member account, but they will be the controller, and then they are making that particular decision. Now, one of the earlier cases that looked at all of this was Katz and Grossman. So I'm going
Yes.
to reel off a whole bunch of cases throughout today's session, because I love a good case. Because, as everyone knows, I'm a big nerd when it comes to this sort of stuff. And the cases just teach us so much to then advise our clients about how things need to work. So there's been a number of cases over, say, the last 10 odd years. Some of them are a bit meaty in terms of just the background facts and things like that. So we'll cover off on a few of them. But Katz and Grossman was one of the earlier ones, and I can't remember exactly when that was. Must have been 2007, if
Uh,
not
yeah, the first I
2006.
heard of it was 2008. So it
Yeah.
must have happened just before then, because that was when the discussion around cats and
Yes.
dogs started. So yeah, it
Yeah.
must have happened just before then. Yeah.
So in 2008, the tax office released an SMSF guidance that said that binding death benefit nominations within an SMSF didn't have to have a 3-year life, because of the way that the SIS Act and regulations is drafted.
Yeah.
I think it was SMSFD 2008-3, or 2008-1, one of the two. And so then that, as long as the deed allowed for a nomination to be what the reference is, non-lapsing, so it doesn't lapse after the 3 years. So 2008 was one of those first years that sort of came through. And then there was another case. So Katz and Grossman, we'll cover off on that one. That was where it was a mum and dad fund with individual trustees. Mum died, and then dad appointed the daughter as the second trustee. Then dad died, and daughter appointed her husband, as the other trustee, just to keep that trusteeship ticking the boxes under the SIS Act Section 17A. Anyway, dad didn't have a binding nomination. In his will, he had an equalisation clause, which said that the kids were to get 50-50. Daughter paid all of the super. Sorry, it didn't have an equalisation clause, but it paid the estate 50-50 between the sister and the brother. The sister paid all of the super out to herself. So really, the brother only got 50% of what would become an estate assets, and missed out on 50% of the super effectively. Now,
And that was
that
legitimate too. I mean, she didn't do
yeah,
anything under the rules. She was appointed as a trustee. She did everything in her power as a trustee to do that. Unfortunately, it meant that she manipulated the situation so
yep,
that she got all of the super benefits. But it is important to note that she didn't actually do anything wrong, as in, I'm not talking about in the moral sense. I'm more talking
yeah.
about in the legal sense that,
Then the legal sense, that's
she
right.
didn't do any rules.
And she was an eligible beneficiary, because under the SIS regulations, when dealing with death benefits, you only really can pay to a dependent, so a SIS dependent, which is a spouse, a child of any age, a financial dependent or an interdependent, or the estate. So she fell within that classification. So then technically she could advance all those funds to herself. Now we have moved on from that, where there has been other cases where that sort of perhaps wouldn't cut the mustard anymore. That whole, well, I'll just pay it all to myself. Um, and so, that was one of the earlier ones where it was like watch out for who the successors of your fund are, because they could well advance that money to themselves. So then there was this consideration, because the fact that you could have a binding nomination that didn't lapse meant that a lot of people could have that position where they nominate someone now, and that's not every 3 years they're having to do it. And particularly if you nominate someone now and it lapses in 3 years and then you've lost capacity, then it's, it's not a free for all, but you can see there's certainly some estate planning issues if the successors were put in place previously and they've got a non-binding, or it's a lapsed nomination. So then what does the deed say about who gets the money? So Katz and Grossman was one of the first ones. And then Donovan and Donovan dealt with the form of the binding death benefit nomination, whether the deed governed it or the legislation. And in that particular deed, it did reference back to the legislation. So it was very much a 3-year term that applied in that particular case. So
Yeah.
a binding death benefit nomination, back to your question, short story long. So a binding death benefit nomination is effectively, it's the member providing a binding instruction to the trustee to say, when I die, this is where I want my money to go. And it's provided it's valid, and that validity is one of the areas that is often tested, and that's where there's lots and lots of war stories. So provided it's got to be binding, and so generally the requirement of that in most deeds is that it has to indicate in that document that the intention is that it is binding on the trustee, and as long as it's executed in accordance with the deed itself, then it is then valid. It has to have the correct or valid eligible beneficiaries in it. So there's been a few cases where the beneficiaries nominated in the binding nomination weren't eligible. So Munro was one of those. And this is one where, as an industry, and you shouldn't chuckle because someone has died, but it just goes to show that, like, that's getting specialist advice is really important. So in Munro's case, the binding nomination was drafted that said it went to the trustee of the testamentary trusts, effectively, or the trustee of my estate. And so the daughters were of the view that that meant the executor or the legal personal representative. And that nomination had been drafted by the father, who was a lawyer, and he had objected to paying for a nomination to be drafted by someone else. So he drafted it himself, trustee of my estate, and then that was called into question by the second spouse, saying, well, that's an invalid nomination because the trustee of his estate is not the legal personal representative. The legal personal representative should be referred to as the executor or the legal personal representative. So then that was considered to be an invalid nomination. And she, as the remaining trustee, could then advance that money to herself. And the daughters could then dispute the will, but the will then had nothing in it because the super just stayed with the second spouse. So you can see the interaction then. If the super gets paid to the will or to the estate, that's when the will has jurisdiction. But other than that, they are completely independent, separate buckets to look at. So, but the will can have some jurisdiction or some impact on the fund and the binding nomination and where death benefits are directed if it's a single member sole director super fund, and so the legal personal representative or the executor becomes the replacement director. So that's where they can interact. So it's just really, really important not to just look at that single document and say, oh yeah, it says that Jemma is paying her benefits here and here. That's all good. File it away. You really need to look at it more widely. And it's, again, that tip of the iceberg might be that little nomination, but underneath all of that is, how does the will interact, if at all? What's the likelihood of dispute? Who are the successors in the fund who are making this decision if it is considered to be invalid? Because you might execute it now and it's 15 years later that the person dies, but over that course of time, there could have been another case that challenges how that was executed. So it really needs to be looked at. And the other one with that, and I'll give some examples of some of these cases here, is we've seen a number of situations where people think that they've got a valid and binding death benefit nomination, but it is invalidly executed in accordance with the deed, which means it's as useless as a chocolate teapot, or it's been executed in accordance with the deed here, but that deed wasn't properly executed. And so that means that that deed is invalid, which means that any documents executed to satisfy that deed are also invalid. So that chain of deeds is exceptionally important. And that was what was looked at in the Re-Narraman case, where there was a chain of deeds. Some were signed but not dated, etc. It had a legacy pension in it, so a complying lifetime pension. So the consideration there was it reversionary or not? A blended family sort of situation there as well. And that was looking at that chain of deeds. That had there was so many considerations in that case. That was also another one where can the power of attorney change a binding death benefit nomination on behalf of the donor of the power of attorney in Queensland? Yes, provided there's no conflict. In other states, like where I am, good old WA, the during power of attorney is not able to amend or update or extend a binding death benefit nomination on behalf of the donor because it's considered to be a testamentary disposition. So there's all these little quirks that come through in there as well. And the other one with Re-Narraman was the binding death benefit nomination had 5% going to the sister, and then got to get my numbers right here, 47.5% going to the son and 47.5% going to the wife, and it was the second wife, and it was their son. And because it had 5% going to the sister, who was an ineligible beneficiary under those CIS provisions, then did the whole nomination fail? So that was one of the questions asked. Then the other consideration was, okay, if we amend that death benefit nomination so that it pays 50% to the son and 50% to the wife, will that fly? And that's where that conflict arose, because the sister and the wife were the powers of attorney. So the wife was getting a benefit in the execution or the changing of that enduring power of attorney. So interesting stuff, right? Interesting stuff.
Yeah, well, you covered a lot of stuff there, Gemma.
Sorry, I thought I'd take a breath and
and might just
yeah.
walk it back a little bit.
Yeah,
Obviously,
totally.
everything that you've mentioned, I think demonstrates quite vividly that there's a lot of interaction with the binding death benefit nomination and a lot of other documents within an SMSF. So you did mention the 3-year lapsing thing, which has been something that's been challenged and a little bit contentious for a number of years, even though that original statement from the ATO said that that rule does not apply to SMSFs. It applies to any other binding death benefit nomination that automatically the nomination lapses after 3 years, but they're very specific about, oh, but that doesn't apply to SMSFs. But still, there was all this contention about, oh no, but if you'd put one in, it'll expire after 3 years. Well, it
Mm.
doesn't. And finally, I think it's probably been put to rest by that court case. Was it a couple of years ago, Hill versus
Yeah,
Zoo?
it was some years ago, not some, but I think it's like last year, but it was like 3 years ago, the Hill and Zuda one. Yeah,
So
that's right, the
that
High
that
Court.
definitive.
So it was yay, definitive from the High Court. Yeah.
So that is absolutely definitive. We don't
Yeah.
like you just refer to that and that whole expires after 3 years is over. But look, I say that,
Well,
but of
but
course that's
maybe
not
not.
actually the true because
Yeah,
like a lot of things it depends,
it
and that
depends.
is where you go. Obviously, we're talking about the interaction with the trust deed
Yep.
and how important the wording of the trust deed has to be because correct me if I'm wrong, if your trust deed says something like, you know, the strategies we put in place, such as a binding death benefit nomination, is just in accordance with law,
With the CIS
yeah,
regulations,
with
with the
with
CIS
with,
Act.
with the
Yep.
CIS Act, then all of a sudden it's like, okay, well, you've now waived the exemption to SMSS because you've put yourself in that bucket of the CIS Act just applies here.
Yeah.
without, without that SMSF exemption. So then all of a sudden you are faced with a situation where if you've got a BDBN, it will lapse
After the
within
3 years. Yep.
period, yeah, after a 3-year period. So it's pretty intricate stuff, isn't it?
Well, it is. And I think the other thing in that the CIS Act and the CIS regulations is it says, there's a 3-year time frame attached to it. There's also really strict execution provisions in there that says it has to be witnessed by 2 independent witnesses over 18, none of who are the beneficiaries, etc. And so that now a lot of deeds don't, a lot of deeds might have similar wording that says, yep, 2 people have to. And this is the thing, you've got to read the deed. And that chain of deeds is really, really important. We've picked up situations where these on annual update services, which I'm not generally a fan of, and this is one of the reasons why the client gets it in the post. They don't read it. They sign something probably not correctly, and then it just sits in the drawer. I've had one recently where the fund's been in place since the 90s, early 90s. One of those sort of like medical doctor sort of person. And then it got updated. And because they then moved on to an annual update service, and because that was more than 7 years ago, they threw out all of the historical deeds. And
Oh,
we're
wow.
looking at it going, oh, goodness. We've got copies, electronic copies, but not of everything. So, anyway, we're doing some forensics there to see, because this is where, I mean, we could do a whole session on deeds. What we're encountering is a lot of those 1990s super funds have got principal employer provisions in them. And so that means that the principal employer has to sign off on any deed amendments. And where often that chain can be broken is because the principal employer hasn't signed off in that capacity. The principal employer is often a related party, but we have seen one more recently where the principal employer is a business that was sold 10 years ago to a friendly, so it can be dealt with, but it's just extra work that needs to be done to get that signed off on. And then we've got, lost deeds, all of those sorts of things, which is what, like, re-narrowment came through all of that. A deed of confirmation was done that said, look, we've got this chain and we want to confirm that really this is the current position that we're in on the basis of this chain, given some were executed properly, some weren't, which one's valid, etc. So that confirmation was done. And then there was also the consideration of, can we extend a binding death benefit nomination? Can the power of attorney do that? Is it a reversionary pension? In this particular case, it was a complying lifetime pension, so quite different to any account-based pension in there. And I know we speak at length about reversionary versus not. So this really, when it's not reversionary, which is my preference most of the time, it's so important to have a robust binding death benefit nomination or other instruction in the fund that is valid, to make sure that if you want the money to go to the spouse, but it not be reversionary, because the background to that, for those who aren't aware of me getting on my high horse about it, I don't like reversionary pensions because the transfer balance cap position is very painful to deal with. And with the Division 296 tax, at the time we're recording this, imminent, then it'll also create an extra tax liability from a Div 296 tax perspective. Anyway, we digress. So if you want the money to go to the correct person or people, then you really need that death benefit nomination, and it needs to be binding and valid and just tick all the boxes. Yeah.
Yeah, it's so important. I mean, look, what we're really saying here, and we say in numerous podcasts, is how important the trust deed is.
Mm.
It's really the document that everything revolves around, really, because you might think that you put something in place and then red flag, your trust deed actually says you can't do it,
Yep.
or it should be interpreted in a different way, or the nomination isn't binding, or whatever it might be. That is the overriding document. And again, to your point, Gemma, if you lose the deed, or you don't have that succession of deeds, if it has been changed anywhere in the past, that's going to be another world of hurt for the
Mm.
trustees. And of course, these things never manifest until they do.
Someone dies.
And,
Yeah.
and then
Or
that,
someone's incapacitated. That's the
yeah,
other thing.
yeah,
We've been, I think, with the legacy pension changes or those sorts of like a lot of people, parents are in care, the kids are stepping in as the powers of attorney, and they're sitting there going, "What's this bloody pension that we're having to deal with here? How does it work?" You know, the deed, the deeds are not don't line up. So they're picking up this, all this time bomb, and they're just really wanting to deal with it. So it's just making sure that everything is looked at. And I think I mean, a lot of that, I feel like in our practice, we've been more conscious of all of that probably over the last 5 or 6 years, that chain of deeds. And the reasoning behind that is because of these cases. So they're blended family cases, which is becoming more and more prevalent. So we even need to be more on top of these things where there are blended families. So, some other examples in more recent times. So the Eopolo or Iopolo case, I think it's Eopolo, out of WA. It's interesting. A lot of the cases come out of Queensland or WA. So Eopolo was a situation, and this is where it's not just that document at the top of the iceberg we're looking at either, but it's the wider impact on the estate planning. Because if the will says, oh yeah, all this money is going to all these people, but then all of the wealth is either in the house or in the super fund, or the house is in joint names and goes to the spouse. So the estate advancing all this money around the place is entirely dependent on the super being paid to it, then it really you need to be looking at like the will at the same time. So in Eopolo, the time frame was binding death benefit nomination was done that left the money to the spouse, second spouse. A will was done after that said, I want to leave all of my super to my kids. And then a binding death benefit nomination was done subsequent to that to say leave everything to the spouse. Then that lapsed because it was more than 3 years. Then the wife died, and the husband changed the trustee because it was individual trustees, and why we hate those. Had to change the trustee to a corporate and paid all the benefits out to himself. And of course, the daughters had the will that said all the super to them, but there was a binding death benefit nomination. Sure, and it had lapsed, but that was indicative of the intentions. And these are conflicting documents to the spouse, no to the kids, to the spouse. So, what were the intentions? You don't really know. And she's died, so you can't ask her. So, all you can rely on then is what the documents say. And the more recent one, which is it goes to the spouse. And this is what a lot of people so then that held, and the spouse was able to keep the money and the daughters didn't get anything. Now, we can make all sorts of speculative comments about, oh, well, he disinherited the step kids, but they could have been bloody horrible. I don't know them, never met them, to him, and had been estranged from the parent. And so this is the other thing is what the documents say is all that you can base the intentions on, is what those documents say. So that's a really interesting sort of factor there. So that was in, let me get my timing right, that was in 2015, so that was 10 years ago. God, that's gone quick, hasn't it? And before then, so that was where the death benefit nomination had lapsed, so was invalid, and therefore the husband was able to pay all of the super out to himself. There was another case in Victoria called Worcester and Morris, where the second spouse sought to say that the binding nomination was invalid and therefore paid all the benefits out to herself. And in the end, it was considered that no, it wasn't invalid, and therefore the children did get a benefit. So you can see, differences there. And of course, everything is so fact specific, but all of this just teaches us what we need to be looking at. So I went through Monroe, which was that terminology is really, really important in terms of who the nominated beneficiaries are. So, and with Ree Narriman on that front, how I mentioned that the sister was a 5% nominated beneficiary. In the end, the court found, because the deed had said effectively that a binding death benefit nomination would only be invalid to the extent that it had a beneficiary that was not eligible. So it would only be that 5% that would be invalidated, not the whole nomination. But you can see again how those nuances and those distinctions are really, really important to be aware of so that we can look at the situation for, because a lot of clients are like, oh, my will deals with that. It's like, okay, right, straight away, you need to open up Pandora's box and say, well, this is actually how your wealth is passing. If you die, if your spouse dies, this is who's getting the money. This is who is in control. And so it's here you go. Is that what you want? Oh, hell's no. I want this, this, and this. Okay, let's fix it whilst you can.
Yeah, and I think you made a very good point uh, in some of the discussion that I think it's taken on greater importance to get this stuff right because of blended families, for instance. I
Yep.
mean, that's adding maybe not just one layer of complication, but several layers of complication with individual relationships between parents and children and parents and the new spouse and whatever.
Yep.
There is absolutely no doubt. Uh, the fact that you've been able to reel off so many cases already, and we see cases discussed all the time and new ones at that, that
Mm,
this is an area of litigation that just continues to grow.
yep.
It's not shrinking, it is absolutely growing. So the less risk that you can have with these sorts of things, it's so important. I mean, you really can't stress the importance. And I always say that, look, these are issues that you have to deal with when a loved one has passed away. So you can imagine the level of emotional
Emotional.
trauma you're
Yeah.
already going through, regardless of dealing with any of this stuff. But to pile this on top of that, and then obviously when money's involved, that's not that's not going to be a good thing either. So it really is important, and I think more important than ever to get this stuff right because you just don't want to be opening yourself up to any sort of challenges. We like to think the best of people, but as most of these court
Oh, the
cases,
worst comes out when
yeah, that's right. As most
absolutely
of these court cases prove that you can't rely on people being of sound moral fabric. And
doing the right thing.
no,
And
if anything, it's
that
taught us,
trust, I don't know, I
yeah,
feel like I distrust any all of these because of the experiences that we've had. And the other thing is, over the last 10, 20 years, super has become the biggest asset, or
yes,
the second biggest asset for most people, but often the biggest asset that they might have when they die. And there's $4 trillion in super in Australia, and $1 trillion. That is so much money sitting in self-managed super funds. And the average, like the age demographic, is most of that would be in the older age bracket, and there's just going to be this substantial wealth transfer. And if this isn't done properly, the courts will be more clogged with
yeah,
litigation.
yeah.
Um, and it's just really, really important that people are aware of it, and they can at least flag it with their clients. And if the client's head is in the sand, then at least you've met your obligations. Because the other thing is, the last thing you want is the kids knocking on the door saying, excuse me, Jemma, you've been mum and dad's advisor, or dad's or mum's, whoever, their advisor for however long, and you didn't identify this, you didn't pick it up. Something could have been done about it. This isn't what they wanted. Well, firstly, do we know what they wanted? That's the first consideration. And you don't want to be on the chopping block yourself for perhaps not considering this. And when you have a look at the FASEA standards, that standard of the longer term, I always forget which the standards are now, by the way, don't tell anyone. So the one where you have to look at the longer term impact that this has on your clients and their wider situation, this is bang on in terms of what this looks like.
Yeah, that's a great point. I mean, getting to the advisor's perspective, you don't want to be opening yourself up to any sort of legal challenge yourself to
Mm,
say that,
that's right.
well, actually, I've suffered financial harm out of this, and
Yeah.
I can take you to court for that because there are provisions that allow, obviously, your clients to do that.
Yeah.
Who would want to open themselves up? And again, I highlight the fact that the courts in was it the Baumgartner case?
Yeah, I was going to use that as an
That,
example as
that
well.
is,
Baumgartner,
that,
whoever had the
that-
deepest pockets. Yep.
correct. It's like these people should be compensated. They've suffered loss. It's not necessarily your fault, Gemma, but
But,
hey, you've
but
got
you've got
PI
PI
insurance,
cover. You
don't you?
probably could have,
Does-
should have looked at that and
And that
alerted them
covers
to
any,
it. Yeah.
yep, and that covers any of these sorts of claims. So guess what? We're going to take it from that pool of money
Yeah.
and the victims get compensated. Don't worry about the fact that your premiums will probably go up as a result of it. And it's not actually your fault.
Yeah. That's
But
right.
the principle was these people need money. Where can we get it from? Oh, there's a safety net that we can potentially draw from. Let's do that. It's not PI cover is not designed for that. PI
No.
cover is designed to cover the professional for legitimate claims against them, not just because it's not your fault, but
Yeah.
you can pay for it, so that's okay. Now, I I keep saying that an extremely dangerous
Extremely. Yeah.
for practitioners out there, and again, it emphasizes the point you just don't want to risk putting yourself in that situation because really, when it gets taken to the courts, the Baumgartner case proves that you're really in the lap of the gods.
Yeah.
That's not
And the
even,
other thing is, so you've got to cover yourself somehow,
yeah.
and this is where it's, oh well, estate planning. That's a wills and estates lawyer. So sure, that might be the person that drafts the documents, but I think in my opinion, the conversation needs to be had to alert the your client to what the considerations are, how a binding death benefit nomination works, or even this is what happens with your super when you die. And so then you can refer them to an appropriate specialist from that perspective. But then having good file notes to say, I spoke to Darin and we went through this and they were not concerned because their will covered it. We alerted them to this and this and this. We've sent them the details of bloody blah lawyers to go and chat to. And then, you've got your file note that says, so when Darin's kids come through and say, Jemma, why didn't this happen? It's like, okay, so Darin Jr., yep, understand, but we did speak to your dad about it. This was the outcome. We followed up, etc., etc. And so, you've met your obligations. Doesn't mean that they won't still crack it at you, but at least, I mean, I don't like to advocate for backside covering, but when you just look at the number of cases that are out there at the moment, it's just so important that we're on top of it because uh, in those cases where, for example, the tax office is taking the trustee of the super fund to task, like in the merchant case and in some other ones that we've seen more recently, that's like the tax office attacking you from a compliance perspective is sure, no one wants that. And you've got to meet your obligations. But this is more like I'll call it more civil because it's, or less civil, but more a civil case because you've got competing beneficiaries. And so they are emotionally involved and sometimes vindictive, and money's involved, and you just don't want to be in the center of that explosion.
No, and of course, human nature is that they're not going to blame themselves.
No.
They're not going to say that, yeah,
Oh, dad
that's
stuffed it up. Okay.
that's all on me. Don't worry
Right.
about it. The whole point that this has been challenged in the first place means that, well, if it actually comes out against me, someone has to be blamed for this. It's not me that's going to wear it. I'm not wearing
Mm,
this. I've lost out. Someone's got to be blamed for it. Hey, Gemma, it's your fault.
it's my
Now,
fault. Yeah.
again, it's not a matter of prioritizing us or backside covering procedures. it's more mitigating business risk because
Yeah.
guess what? If you have one of these cases go against you, that could be it for the business.
Mm.
That could be wipe out, finish, forget
Yeah.
it,
Wipe
over.
out. That's right. Yeah.
So it is really important. It's a shame that we sort of have to go down this path, and that has to be, one of the main considerations when you do this sort of stuff, because I don't really think it's that productive. But of course, you don't want to be the one left holding the can when
Yeah.
this stuff all comes home to roost. Now, Gemma, I'm going to risk putting you back on your high horse now because.
Oh, okay. Oh dear.
Well, we're talking about
Well,
binding
you
debt.
know, I love being on the high horse.
Yeah, well, high horse, soapbox, whatever you want to
Mm.
stand on or sit on. But you did mention reversionary pensions before. I know that we're not talking about reversionary pensions today, but whenever the subject of binding death benefit nominations comes up with estate planning, there's always this argument of BDBNs versus reversionary pension.
Reversionary. Yeah.
And what happens, which takes precedent if there's conflict or whatever. So, I don't know, do you want to share some thoughts on that?
Well, like the answer to any question in this space, it depends. So some deeds actually cover off on that and say if you revert your pension to your spouse, but your binding death benefit nomination says all of your money goes to your estate or directly to your kids, then a lot of deeds will list which documents take precedence and what that cascade looks like. So I've seen the situations where it says reversionary pension first, then valid binding nomination, then non-binding nomination, then trustee discretion. I've seen other ones that say binding death benefit nomination will take precedence, then reversionary, etc., etc. So again, the importance of being on top of what your deed says. The other thing is that a lot of people use, most people use a lawyer or a deed provider, and they might update their precedent. So you might have a deed from 5 years ago that's silent on this. And so you're thinking, oh, okay, well, what does that mean? And I'll get to that in a sec. Or that says, like my first example of reversionary, then BDBN, etc. But then they might change their view and think, actually, we prefer from an estate planning management perspective that it's BDBN reversionary. And if you're not on top of what those changes necessarily are, from because you might have updated the deed for 10 of your clients to the 5-year-old one, and that's still perfectly, you don't need to update it anymore. And then you chat to Darin, Darin's got that deed, but you're thinking about this new deed because you've just set up 5 funds with that one and you've read through it and gone, yep, yep, yep. And then all of a sudden it's the different one because that, just the same provider can update what their requirements are as well. So it's not just being a case of, oh, well, I've used that same deed provider for 15 years. Therefore, it's going to be the same. You always need to have a look at what that looks like. So the deed will tell you, but what if the deed is silent? So the answer to that is we haven't had that tested yet. So the tax office has a view, and this is from a national tax liaison group meeting. Oh, it would have been over a decade ago, 2012 even, maybe. I can look it up, where they had said the tax office. So again, they're not the courts. They had said if it was a valid reversionary pension, then they would expect the reversionary pension to take precedence because that doesn't stop. That's a contract for that pension to continue on, and therefore there'd be no reason for the binding death benefit nomination to kick in with respect to that pension because it sort of continues on. Now, in the Narriman case, there was the consideration of was the pension reversionary or not, but we cannot rely at all whatsoever on the ruling on that, which was that it was reversionary because that was a lifetime pension. And with the lifetime pensions, the actuary had done the initial calculations on the basis that it was a reversionary pension to the spouse. And so that was considered to be quite a telling factor with respect to that pension, because back when it was set up in pre-2005 in the SMSF, that's how it was set up and has been run over time, notwithstanding that the original pension documents couldn't be located. So that doesn't mean, oh yeah, well they said it was reversionary because that's what it said on in the fund, not just like the original pension documents were lost. So just because the fund said it was reversionary, we cannot rely on that at all whatsoever. And this is, I digress here as well. Sorry, but still on the soapbox. Still on the soapbox. Those original pension documents that say if it's reversionary or not are unbelievably vital. You know, you've got your deed that says various things, but those original pension documents will tell you if it's reversionary or not. And so, again, this session isn't supposed to talk about really reversionary or not because we've done that before, but just unbelievably vital to find those. And it's not just a tick the box because there's just so many other implications from that perspective. So I'll step down now.
No, no, no. I opened the door for you
Yeah,
there,
you
and
did. You did. It's your fault, Darin. It's your fault.
I, I suppose in a lot of these cases you can apply the Bart Simpson principle, can't you? That if you can't have those documents, ready and present and a history of them, it becomes a matter of I didn't do it. Nobody saw me do it. You can't prove anything.
Yeah.
That's the Bart Simpson principle, isn't it? So,
Well, and then I envisage then that footage of Homer backing into the hedge. One of my favorite memes that's out there. Now, just in the interest of time, so we've gone through a few cases. It would be remiss not to cover off on some more recent ones
yeah,
because what we've been talking about so far has been the sister disinherits the brother, the the stepdad disinherits the stepkids, the stepmum tried to disinherit the stepkids, the stepmum did disinherit the stepkids in all of these other ones. And there's a whole bunch of ones that I haven't really covered off on. But there's more recently that consideration of someone being able to disinherit another person with that exercise of trustee discretion did come through in more recent times in the Marcella case. And that was in an SMSF context. And then not long after that, in a family trust context, was Owies. And so Owies refers to Marcella. And so both of them are relevant when the consideration of this trustee discretion. So in that case, so Marcella was in 2019. Oh God, 2019. I feel like it was like last week, but no, 2019. So in
pre-COVID.
yeah, I know, right? Goodness, it's making me feel quite old. Anyway, we digress. So, in Marcella, the daughter was in control of the fund after her mum died. She had a brother as well. Both the brother and sister had their own children, and there was a stepfather in the mix as well. So, mum and daughter were the trustees of the fund, and the daughter did not have a good relationship with her stepdad, and so she and there's a lot of evidence to show how fractious that was. And so in the end, she paid all of mum's super to herself on the basis that mum wanted the money to go to her grandchildren. Now, that is a challenge to justify when you've paid it just to yourself and your brother also has children. So your mum's grandchildren are not just your children, but anyway. So in that case, that's where the stepfather or previous stepfather, even that stepchild, step parent relationship is one that's tenuous when it comes to superannuation and estate planning as well, but that's a whole nother topic. Anyway, in Marcella, the stepfather took the daughter on and said that she hadn't exercised her discretion in a fair and reasonable manner, and he was successful in having that that determination sort of in his favor, saying because of the animosity, then so a trustee doesn't have to tell everyone why they've exercised their discretion in a particular manner. It's their discretion. But because of that animosity, it was, and there's various bits and pieces if you want to read the case. Again, fascinating stuff for nerds like me. Is you can just see that flavor, and absolutely, it was a spiteful sort of distribution of assets. Also, the stepfather had a financial need from that perspective. So you're almost overlaying an element of family provision claims, although that's not how the law operates. But there was certainly the consideration of he needed some financial support. Therefore, she didn't really appropriately consider that as part of she just paid it all to herself because she hated him in a sort of nutshell. And then in Owies, that was further sort of expanded on from that perspective. So it's not, if you then think, okay, well, 5 years but prior to that was the Iopolo case, which was where the stepfather paid all the money to himself. Then there was the ones where the siblings disinherited, like Katz and Grossman. In Munro, it was the stepmother that was able to take off with all the money. And again, what are the intentions? We only know those from what the documents actually say, what the valid documents say. So it's really brought to the fore since then the importance of a claim staking process. So looking at who are the eligible beneficiaries. This is in the situations where there isn't a binding death benefit nomination. So it's really highlighted the importance of having a binding death benefit nomination or similar document that is robust and pays the money in accordance with the intentions. So with Marcella, that whole going through a claim staking process, who are the potential eligible beneficiaries? Is there, and it doesn't necessarily need to be, is there a need for them, but you have to have considered them to then be able to make that relevant decision. And if you have a look at Gainer, which was a podcast that we've done previously, there was a lot of time spent by, got to remember the chap's name, Mr. Hess, I think it was, Mr. Heath. Anyway, the independent trustee in their role as a director to determine who was an eligible beneficiary. And that was put to task by Mr. Bone, I think Stephen Bone was the spouse that was saying, well, I should get all the money because I'm a tax dependent and it's more tax effective. And the outcome of that was a third to him and 2/3 to the estate. Anyway, there's been some other cases. One is Ievers, which is Ievers. And that spoke about how, look, it makes sense to pay all the money to the spouse because they're a dependent on you, it's tax effective, but that doesn't mean that they will have the ultimate right to get all the money at the get-go. So that Marcella one has really brought the importance of, if there isn't a binding death benefit nomination or similar document, then the trustees really need to show that they went through a process if they are ever challenged. And blended families, you'd be wanting, so there's schools of thought. Do you really want to document it and say, oh, well, we considered Darin, but, he doesn't need it because of blah, blah, blah. And then you're going into that nitty gritty. It's more evidence, like with what Owies demonstrated, more evidence that you did at least consider them. So you knew what their current situation was, because in Owies, they hadn't been in contact with their children for years and years and years. So didn't even know what their financial situation was. But these days with Facebook and social media, everyone shares their intricate details. So it's probably a bit more challenging to demonstrate that you weren't actually considered. Anyway, we digress a little bit there from that perspective. But that was certainly that Marcella one in more recent times has, so 2019, Marcella, Hill and Zuda, which was that High Court case that said it's what the deed says. And if you can have a non-lapsing nomination, you can say that the deed might say that the execution of that is, you just sign it. You doesn't have to be witnessed necessarily. Maybe you can sign it electronically, all of those sorts of things. So the deed is then that paramount document, but the correct deed is the other thing with that.
Wow, it really is so intricate. And I suppose the one thing that you need to take into account is that you can't predict human behavior either.
Hmm.
I think in all these cases, the deceased person probably needs to understand that potentially they're the glue to all of these
Yes,
relationships. And
they
once
are.
the glue has gone, and that doesn't necessarily need to be blended family, as in second wife or whatever. And then you've obviously got warring factions between the original children and the stepmother or the stepfather. I
Yep.
mean, look at Katz and Grossman. That was just brother and sister.
Yeah.
That didn't have anything to do with additional parties where, oh, because my dad or my mum married somebody else, then immediately I'm against that person, which obviously can happen. But in Katz and Grotzman, which is the original
The
case
OG. Yep.
that brought all of this out, that was just brother and sister.
Mm.
Like, but did the father realize that? Well, I'm the thing that bonds them together, and once I'm no longer here, what are they going to do? And you can't. I mean, again,
The
you can't.
family dynamics and the family politics and all of that sort of stuff, that in itself is a whole, like a big area that I, in the last, well, however many more so than, well, a lot more now than perhaps historically I've just seen, having to sit there, like you've got to, those personalities, if someone's died, like even if it's just one parent that's died, everyone's grieving in a different way. So someone might be here, but someone else is down here. So until they've met, they are ready to deal with things, all of those sorts of considerations. And just the expectations on all the parties can be different as well. So it might be, oh, well, I was discussing with mum before she, like in Marcella. Well, I spoke to mum and she only wanted the money really to go to her grandkids. Okay, well, then stepdad possibly also spoke to her and she was like, oh, I'll look after you, mate, sort of thing. And the son might have been in a similar, yep, it's going to the grandkids. And then all of a sudden, this is what happens. So that's what all people are also fighting about. And we haven't even spoken about family provision claims, which is that whole consideration of if it gets paid to the estate, it can then be open to dispute. Now, I know New South Wales has got notional estate provisions, which is different to all the other states. So that's a whole other thing as well. But, have you, in paying super perhaps external to these as to sort of bypass the estate, to bypass a dispute. Now Marcella's almost opened that up if that's the exercise of someone's discretion for that consideration and why that claim staking is important. And then if your super does go to the estate, the consideration there is, of course, that that is open up to dispute. Have you adequately provided for all of those potential eligible beneficiaries? Da, 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 da. So again, I can talk about this underwater, as most people will know. But it's just so many different areas that we need to be able to navigate and be aware of.
Yeah, and I think the added layer to that is, and this is really unfortunate, but this again is human nature, that once significant sums of money are involved,
Mm.
that changes behavior. And that, in a lot of cases, I hate to admit, can probably bring out the worst in
Yes, it
people
does.
and probably the most vindictive uh, elements of a character, because if you feel that you've been wronged, and this is basically what it always comes down to, isn't it?
Yeah.
Well, I think I was entitled to more of that, more of the slice of the pie, and I didn't get. In some cases, I didn't. In Katz versus Grossman, I didn't get any.
Any. Yeah.
So, I'm aggrieved, and we're going to go to court, and unfortunately these situations just tend to bring out the worst in people.
Well, it just
All
ruins
the
families as well.
Yeah,
So it just
yeah.
ruins those relationships. Even like sometimes it's like, look, I've absolutely seen situations where the siblings have gone in and said, look, that, excuse me, that doesn't seem fair. I'm pretty sure that, I've got enough money. I don't need it. Let's adjust. So fantastic. But that's probably 10% of the time or 1% of the time. And the other times when a deed of family arrangement needs to be done, it's because someone feels like they haven't been adequately provided for and there's an adjustment in their favour. So if people are going down that path, you don't want to go to court. It's, you want to do it all via mediation or the like, but we just want to try and avoid it um,
But,
entirely at the get-go.
well, well, the court situation is. is just a terrible scenario anyway. I mean, I was told anecdotally of a situation where, again, it's a brother and sister feuding over the superannuation and the superannuation fund, and the benefits are just getting completely whittled away, like
by
significantly
fees.
whittled away by legal fees.
Yep.
And it has been proposed that, look, do you really want to do this? Because really, you're spending so much money on the legal process. You know, the benefit is shrinking. At some point
Yep.
in time, the benefit will have shrunk to the point where you got to ask yourself, well, was it all worth it? But
Mm.
again, you know, people are very stubborn about these sorts of things and determined about these sorts of things. I think that case is ongoing because basically it was a matter of, yeah, well, come what
It's a
may,
matter of principle. I didn't get
I'm
enough
I'm
and I
gonna
want
I'm
more.
gonna
Yep.
pursue this, and nobody, but nobody can convince me otherwise that it's going to be, you know, a bad idea to do so, and that's just it's terrible, but you know, that's why we have to put these mechanisms in place to make sure that you just protect yourself from having to go through some of these scenarios because the slightest little
Yep.
door ajar, they'll be in there.
And that's
You,
why the attention to detail required on, have you checked the deed properly? Is it a valid deed? What's the chain look like? They're not little things that you can just be dismissive of anymore, just in light of all of this litigation. And that what you were just mentioning with all of that, the legal fees on things. There was a matter in WA where it was not a super fund, but it was an estate that was disputed. And ultimately, I think it was $1 million estate, or 800,000 was what was the original amount. Their legal fees were $600,000.
oh,
So,
no.
and the judge was scathing in their judgment against all to say, you guys should have sorted this out years ago in mediation, rather than basically charging 600 grand in legal costs, because every person who was disputing had to have their own representation, as an
Yeah, yeah,
example.
yeah.
So we're just trying to avoid that as much as possible. But sometimes, as in Narraman, in re Narraman, the court is required to provide an interpretation. Like in Gaynor, that was another thing of, look, we need to be able to charge a fee for this director service because the guy's done 150 grand's worth of work, but he can't charge for it because the SIS Act doesn't allow it. And, what do we do about it? And so that, the court did provide a ruling on that, and certain other things. So, and on, was it a fair and reasonable, did the director exercise their discretion appropriately in the distribution of that estate? So sometimes the court is required, and that's when we as practitioners really, well, I always benefit from those cases, because I'm like, oh, okay, note to self, just to check that matter for this client. Oh, let's just double check. How does the deed that we use, how does that flow out from from that approach? And yeah, we do have clients that have got independents that step in. So we just need to be on top of that in terms of the SIS regulations and the SIS Act in terms of trusteeship and things like that. Now, I'm very conscious of time because we're good at just keeping on talking. And so just the final thing is, the succession of the fund is vital as well, because if it's an invalid binding death benefit nomination and the wrong person is at the helm, so Katz versus Grossman, it was the daughter. In some of these other cases, Munro, it was the stepmom. But again, you don't know what those intentions were. In Iopolo, it was the stepdad, etc., etc. Then they're the person that might ultimately be making that decision, and are they going to exercise that in accordance with what the objectives are? And if we don't, we might not know what those objectives are if the documents don't support that. So it's just making sure that that's done properly. Now, I've got loads of war stories, but I'm going to cut myself off, which is very difficult to do because I like the sound of my own voice, but I'm going to hand back to you, Darin, to for some closing bits and pieces.
No, that's a really great point, and I think I like the takeaway message of nerding up about these cases, just
Oh,
to
yeah.
protect yourself and to learn the takeaway lessons from them, so that as practitioners, you don't suffer the same fate as other people have already learned from their
Mm.
lessons, because unfortunately they had to learn the hard way in a lot of cases. So that's maybe a slightly more positive note to to end on
Yeah.
there.
Well, at
But
least we're armed. So awareness, where that's, I think that's the other thing is you're aware and you know the things to look out for. And then you know to, okay, let's get a specialist lawyer involved. Um, let's look at it more closely. Let's talk to the client and say, look, Darin, we just want to really check out this chain. Is it right? Is the current deed that was dated 2025, is that actually valid? And I think I've mentioned in previous podcasts the importance of that chain and getting, perhaps as part of your workflow, because we've all got so much capacity at the moment, not is to, have a go through a project perhaps of making sure that that chain isn't broken.
yeah, 100%. Well, that's probably a good place to end it before we go off piste again.
Yeah.
So, look, thanks again, Gemma, for your time and for doing this podcast with me. As always, it's been an enjoyable discussion.
I love it too, Darin. Good old nerding it up. It's fantastic.
That's right. Thanks to my production team also for putting these podcasts together and publishing them at the appropriate time. But most importantly, thanks to you for joining us and listening to this discussion about BDBNs. We hope that you've got something out of it. And more importantly, we hope that you've enjoyed listening to it or viewing it as much as we've enjoyed bringing it to you. Until then, we look forward to you joining us on the next cross country superannuation podcast. And until then, travel safely and bye for now.
Bye, everyone.